Welcome to eDiscovery Leaders Live, where I get a chance to chat with luminaries in eDiscovery and related areas. This broadcast is sponsored by Reveal Brainspace, the industry's leading AI eDiscovery platform. Don't forget to subscribe to watch me, George Socha, weekly with leaders in eDiscovery. Thank you for tuning in. Welcome to eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. I am George Socha, heading up brand awareness at Reveal. On each episode, I get a chance to chat with luminaries in eDiscovery and related areas. Past episodes are available on the Reveal website. Go to revealdata.com, select resources, and navigate from there. Our guest this week, I'm in obviously a different location. I'm at the Masters Conference in Toronto. Our guest this week is Tanya. She's with a senior project manager at Johnson Hana, and she is joining us from Dublin. So, Tanya, welcome.
Hi, George. Thank you.
Glad to have you here. I'd like to start, as I so often do, by asking you, before we talk about what you do and the topics we've got ready, who you are, what brought you to eDiscovery, and what your current role is. So how did you get in this whole thing in the first place?
Thanks, George. So I'm a qualified lawyer, solicitor here in Ireland, and my background was that when I was training to become a solicitor, I worked in litigation mostly, and when I qualified, I moved into big law, up into the one of the top five law firms here in Dublin. I went in as started doing document review for eDiscovery projects. That was the need at the time in the law firm, so it was kind of all hands on deck. Everyone was thrown onto the discovery projects, and I'd never worked on an eDiscovery platform before. I didn't even realize, what was going on with that. Like, my experience of discovery before that as a trainee was traditional boxes of hard copy documents, scanning documents and sending them over to the other side. So it was a whole new area for me. So worked on a few discovery projects in the law firm, and then became an associate there. And while I was an associate, I worked on a very large investigation for 2 years here, and this is all on Reveal. The firm that I was in was working with Reveal and still are. So I was there for 6 years and kind of ended up working just, I suppose, by default on large document review projects. So when I left the law firm, I actually came to Reveal and worked there with yourselves for over a year. I was a project consultant. So at that stage, I was working with still a lot of clients in EMEA, but also some international clients. It was a huge departure from the law firm in that I got a big upskill in, I suppose, the kind of technical aspects of discovery, like a lot of data processing, the back end, the stuff that I wouldn't have done as a lawyer, which has actually served me very well now in my current role. So I was there for a year with yourselves, and then I moved to Johnson Hana. So I'm here 3 years now. In August, and I'm a senior project manager in the team, and work mostly on discovery, DSAR, FOIs, kind of large scale document review projects. And here in Johnson Hana, I'm combining, I suppose, what I've learned in the previous roles. I have the legal experience from the law firm, the technical experience from Reveal, working with international clients on workflows, AI, and then the project management aspect in Johnson Hana as well. So, working on all three at the moment has kind of brought me to this. So I suppose however many years ago when I qualified as a lawyer, I didn't expect to be doing this kind of work, but very enjoyable.
Didn't expect to is probably an understatement.
Yes.
You probably had no clue that you would ever be doing something like this.
Exactly.
So tell us a little bit then about Johnson Hana and what that organization is like.
Yeah, so it's an ALSP, one of the kind of only kind in Ireland, really. So we have two or three kind of business models. The one I'm involved in is the project-based work, where we work with law firms, in-house teams, and on like kind of large scale process driven projects. So, our opinion is, let the lawyers do what they do best, which is, the specialized casework, and the kind of the process work for discovery is better managed, like outsourced. So that's my area. There's other areas within my team, do commercial contracts, um, other kind of project work. And then we also have our secondment model, where we have on-demand lawyers that go into very busy in-house teams, or legal departments, to help kind of fill with, I suppose, uh, resource issues, or just if a large scale project comes in as well. We also help out with that.
For the discovery side of things, what do your clients look like?
So it's been changing a bit. Recently, we've seen a huge amount of collaborations with law firms. So outside kind of the I suppose top five, or some of the firms that have those in-house capabilities themselves, there's an awful lot of firms that are doing discovery work, regularly, but just wouldn't have the experience, workflow capabilities, and resources in house to be able to do it themselves. So we are seeing a huge amount of engagement with law firms. Um, that's probably on the discovery side. Sometimes clients will come directly to us and say, we have a discovery project. Obviously, by its nature, discovery needs to have a law firm involved. So they will say, their preference is to have us do the discovery aspect of the litigation, and then we end up working with the law firm, or it comes straight through the law firm themselves to say, okay, we have this case, we need help with the discovery. Our recommendation is that you're going to go with Johnson Hana. So it does come in both ways. And then I suppose the other document review work that we do, I suppose that, DSARs in particular, that's, a lot of in-house legal departments. Sometimes with the DSAR work, if you get one or two in, it can just completely drain resources from the team. And with the kind of tight timelines for DSARs, the statutory deadlines of, a month, and then you've got your 2 months extension, it can really cause a huge issue for in-house teams. So we do find we do an awful lot of work with kind of legal tech companies. I suppose the kind of the global redundancies has had a big impact on how much DSAR work we're getting. People tend to be using it now as a bit of a fishing expedition for, potential workplace litigation. So we are seeing a big uplift in that as well, from tech firms, and from, I suppose, just companies in general, for that kind of work.
So if the global redundancy is helping bring about an uplift in the DSAR work, what's causing the uplift on the discovery side?
I suppose with the discovery side, it's I think that the format of the data these days as well, like, it's, as gotten so vast. So what would have been, is it like traditional, boxes of documents that you would get now, pretty much every discovery looks like it's, you've got millions of documents coming in, and it's just something that, the traditional lawyer wouldn't have the skill set to be able to deal with. So the process that we would have of, the culling of the data, potential use of AI, even just navigating the platform without, any other kind of formal training from anyone, it's just not something that, like, the traditional lawyer will be able to do. And then you have the actual review itself. So, what again might have been done by a small legal team, if there's a discovery that's taking place over 12 weeks, that whole team is pulled for the entire duration. They can't get any other work done. So it makes sense to kind of look elsewhere to see, how best to get that done. So I think that's been a huge change in it, as well. And now I think as well there's like an expectation from the industry, that when you give discovery, it should be given in a certain format. There's a guideline that we tend to call the Bible here, which is the Commercial Litigation Association of Ireland have a guide on e-discovery, which outlines, the recommended format the documents should be in, how the review should be carried out, up to like the scheduling, the affidavits, everything. And, using that can be like really helpful. We do see it a lot when people deviate from what is expected as an industry norm. That, recently you have someone giving over discovery in like, 1,000-page PDF and saying, here you go. And you're saying that's not how we do it anymore. We need to have
Mhm.
our load files, and we need to, have everything scheduled properly. So um, we do find that an awful lot as well, that, sometimes um, sometimes we'll be brought in once discovery is done, potentially done badly, and that, they need help to get it into the format that is expected these days. Um, so I think that's been a big change as well.
I know that when I started practicing back in 1987, it wasn't unusual for an entire case, by the time we finished the case and we're closing it out, for
Mm.
everything in the case to fit into one regular box. Not just the discovery documents, but
Yeah.
everything that we had to send off for, to be stored in the archives for 7 years. Clearly, that's changed enormously, but maybe the training for the lawyers hasn't changed so much. It sounds like when you're brought in, there probably are a whole set of things that you need to do to help those lawyers come up to speed with dealing with what they now are confronted with. Is that right?
Yeah, and it's that workflow assistance, I think, for Johnson Hannah that kind of sets it apart as well. That, some of the companies that firms might usually partner up with would be more on the software side, wouldn't necessarily have like, lawyers involved who've worked on discoveries for years to help with, the basics of even, picking search terms, variations on search terms, email threading, data culling, all the things that we do all the time is like, as a project manager in the e-discovery world, that are completely foreign probably to solicitors working, on these big cases. So I think that's really helpful for them when we become involved, and it's also like a sense of security for them, given all our experience. So they say, okay, these guys know what they're doing, and can kind of hold our hand a little bit throughout the process, just to ensure that the best quality of work is provided. Because, like as I said before, you do see sometimes that people would say, okay, well, we'll try and reduce costs by not using an e-discovery provider or not using a platform, and inevitably it has to be redone, and then the costs end up being double because they have to do it twice. So, that's a big, like, selling point for ourselves is, we do have, you know generally, a much bigger reduction in costs than, the traditional, like, big law firms that would do this type of work as well. Like our team, we have, the dedicated project managers as well. So, that, like, kind of reporting every week, the forecasting, like the pain points that we would usually see for law firms trying to do it themselves. Like, we've looked at that carefully and said, okay, what are the main issues that they're having if they're trying to do this, and how can we fix that? And what I would say on that is, it's even the management of, reviewers. We have a really great team of, legal consultants that we use on all our discovery and document review projects. They're contracted at a certain number of hours a week. So we can really easily say, okay, if we have, 8 consultants working at 25 hours a week, like, this project is going to get done on this date, given the average review speed. And, if we get more documents in, or, the pace drops, we'll adjust accordingly. We have more, another bench of other people we can add up very quickly, which is, it's great. And that kind of, it's all the aspects of it. It's, our comfortableness with the technology, with revealed capabilities, the project management of the consultants, the quality of the consultants, And then I said like that workflow assistance that we're giving that I don't really see an awful lot of other companies providing. What I've heard as well is that sometimes the technology is given and the firms are said like off you go, you establish whatever workflow you want. So it's that
Here's a tool, good luck, right?
pretty much, and there is that kind of gap in knowledge that I think that we're filling quite well.
So let's pick a common scenario, a common workflow. What would that look like?
Yeah, so we have a couple of different types of discovery work that we're regularly seeing. I suppose we have the standard discovery where we have a court order is made, we are brought on at that stage, and we help, I said, from the search terms to the workflow implementation, we help with data collection with the clients, and then we, set up the workflow on Reveal. Um, we do use AI depending on volumes. You probably know yourself that we are probably a little bit further behind in this jurisdiction than yourselves in the US. Implementing it obviously has been approved in the Irish courts in the IBRC case, but it's not as people aren't as comfortable around it. So there's definitely a bit of pushing on it and saying like this is good, that we can use this. So we do tend to use it as a prioritized review in any event, so that like the law firm are getting the most relevant documents at the start of the review. Probably less common is obviously like leaving the documents behind. There's still probably a little bit of nervousness around that, but I think if you get to a certain number of documents, that conversation does need to happen. So that would be the standard discovery. We would be involved with managing the review, as I said, like doing the forecasting, ensuring the deadline is hit. And then even up until the end of the discovery, I think where we give real benefit to clients is in providing that information for the affidavit of discovery. So that will be drafted by the legal team, but our methodology reports that we prepare, which outlines the collection, the review, having that given over to them and being implemented into the affidavit, that's been good feedback for us, saying how helpful that is. And then preparation of schedules as well for the affidavit of documentation, the cross checks that we're doing. And then obviously just the production of the data in a format that's correct to the other side. So that would be the kind of the usual discovery. We are usually kept on, for the point after discovery is given. Inevitably, queries arise. No matter how good a job you think you've done, the other side, I'm sure, will try and poke holes in what you've done. So we find that because we've been involved from such an early point with the collection and, with the, I suppose, establishing the workflow and everything, that when the queries come in, we are best placed to help them deal with that. And, having all the documentation on Reveal, being able to search, this document was queried, let's go look at it. Why wasn't the parent given, or why was the attachment not given, or let's look at an email thread. Like, it's much easier to navigate around those queries using that platform. So we help out with that. And then on the other side, we have, when we give discovery, inevitably discovery is also given to us as part of the exchange. So what traditionally would have been done probably by like counsel here, they would go through the documents themselves, which was fine, as you said, when there was, a lever arch folder or something. Now we're looking at, 15,000 electronic files. You're not going to have a barrister do that. Probably not, very unlikely. So what the benefit that we would give in that scenario is that, one, our reviewers are already very familiar with the case and with what potentially is a hot document, a sensitive document for that matter. So they can go through the materials, flag anything that's of particular concern that they think the legal team should look at, and also kind of categorize the documents into, certain things. So the client might say, like, let's keep an eye out for these. Can you try and locate them? What we've seen happen before, if that's not done, if the documents are just reviewed off platform, it has happened in trial when a document comes out and someone says, like, where did that come from? I haven't seen it. it wouldn't happen if you're doing it on a platform, because there's an audit trail making sure everything is tagged and eyes have been on everything. So, that's a real benefit as well. We also find with the rate, we would review the other side's discovery and raise queries. So if we're seeing discrepancies in it, we can help the law firm raise those kind of queries to the other side. And those queries are kind of twofold. You have like the high level issues, which are, this wasn't done well at all, it's in the wrong format, we think there's a huge tranche of documents missing, or like document level queries where you're like, that's not good quality, give us a better copy. So, we help with all that work as well. And then um I suppose the kind of the other side of the what we're doing as well sometimes is that, which I think I alluded to earlier, I mentioned earlier, that discovery is done, it's not done to the standard that either the other side of the court is expecting, and then we are brought on to fix things. So that is what we would do in that instance, is we would meet with the clients, go through the
Now, this
process.
would be a separate type of engagement, right?
Yeah, different type. We wouldn't, they would have done it on their own, or
Mhm.
had a team do it. And um I said, either it could be at the stage of the queries being raised and saying like, okay, we better, get Johnson Hana in to redo this or to help us out to get it sorted, or that it could be, at the stage in court where further and better discovery has been requested, and that there is potential for their defence to be struck out for failure to comply with discovery. So that would be obviously on the more serious end of things, and no pressure for us coming in to try and sort that out.
None
Uh,
whatsoever.
None, exactly. And there, what we would do is we would review the process that they've undertaken, recommend whether it should be redone, or hold fixed or something, filled or something like that, or as I said, help them kind of redo it and prepare a report. And we have seen, even from the process of engaging us, does go a long way to show the court, okay, well, they're actually, taking it quite seriously now that they've, employed the e-discovery experts to come in and to help out. So we have seen that as well. So they're kind of the most common ones that we're doing at the moment, but quite varied type of work.
So I would hope with that latter example, tell me
Mhm.
whether this actually happens, that having had some challenges with the approach they initially took, and having had to come to you for correction in course, that you see them come back on subsequent cases so that it's more like example one and example two that you gave and not example three.
Absolutely. Yeah, I think it's, once they see the benefit of it, and the cost benefit of not having to do the exercise twice, it is, we do see a lot of repeat work. In general, you see repeat work. I always say you're only as good as your last project with someone, but yeah, we do find that it's the kind of the risk of the fear of the unknown, I suppose, when they say, oh God, an e-discovery provider, what's that going to look like, and using AI, um, and then when they do use us and they see the benefit and they don't get their defence thrown out in court, I'm sure they're happy to come back.
You have to have discerned in what you've been doing and what you observe some trends in e-discovery in the jurisdiction you are in. What sort of things have you seen and are you seeing? Where are things headed?
How are things at it? I do think more comfortableness around the AI use for sure, which we've mentioned. Um, it is definitely becoming more common. I suppose, even as I said, the kind of compliance with that CLAI guideline for discovery, in that, whilst it's not enshrined in the orders of the courts here, it's becoming more and more, not acceptable, but I suppose the norm that everyone is doing the discovery in a certain way. Maybe when I had started a few years ago, we were seeing an awful lot of the single page PDFs coming in, or hard copy files still being dropped at doors. That is, I would say, the exception rather than the norm now. So we are seeing progress there for sure. Another trend that I'm seeing is, we usually, well, you usually would have thought that, with discovery, we would say discovery doesn't trump GDPR, but it's certainly a bit of an exemption to it, in that, Article 6 allows for, data processing when you have a legal obligation, which is the court order.
Mhm.
Um, so maybe before last year or 2 years ago, we would very, very rarely see discovery going out with redactions on it. Um, sorry, we would have redactions for legal professional privilege, of course, but just not really for third party data. Third party data used to be kind of strictly for DSAR or GDPR work, any privacy projects. But what we've seen recently is there's a real concern about releasing sensitive third party data in a discovery project.
Mhm.
Now, the the case law, there's been kind of new case law on it recently. There was a case in January of this year for the HSC, and it involved foster children. The material was very sensitive and had third parties that weren't involved in the case. And the judge did allow for the documents to be sent in unredacted. What he said there was that it was a discovery of confidential documents is a careful balancing act, and that you can only discover documents in circumstances where the interests of justice in bringing about a fair result require the discovery to be made. So there was definitely more of a concern on, like, the sensitiveness of, the third party data being released. And then also with the redactions, I suppose the rule there is um, you should avert to it in the affidavit, if possible, agree with it with the other side. And then the general thing is that if you do the redactions, that's fine as long as the other side it doesn't impede them from full review of the document. So if you're redacting someone's name, they can still see the content. That's of no issue to them. So whilst it obviously probably will increase costs slightly, and it's a bit more burdensome for the person having to do it, it is becoming slightly more acceptable, which I, it wasn't always the norm. Things used to go out unredacted completely. So that's something I've definitely noticed recently.
What then? I can imagine answers, but I don't know the answer. What happens in this situation where um, a party redacts information? The receiving party looks at that and says, well, that's fine and all, but you've redacted so much that I can no longer get at the content I need to
Hmm.
be able to do my job. How is that resolved?
I think that's probably resolved through a row in court in front of a judge, I would say. So a motion would inevitably issue saying that, the redactions haven't, like, impeded them from actually reviewing the material, and it's causing, as I said, like an inability for them to run their case properly with the documents provided in such a manner. And then I haven't seen it in practice, but I would presume that it would end up with the judge probably reviewing the documents in unredacted form, or a member of the court, and then making a decision on it, much in the way they do with privilege. If they're, you know, as you know, when documents privilege schedule is provided, and there's certain back and forwards, on whether privilege was correctly asserted, um, you can only go back and forward so much to a point, and then you have to issue a motion and get before the judge to suppose have a look at the documents and see if privilege was correctly asserted. So I would imagine it would probably run similar to that, I think. But we haven't had that issue yet, George. So we're hoping not.
One day. So this, so
One
this
day,
this has been then for you quite a voyage. Nothing.
yeah.
What you're doing today is nothing approaching what you thought you were going to do
Yeah.
when you first said, "Ah, I'm going to go be a lawyer."
Absolutely. When I was down the forecourts in Dublin as a trainee, I didn't think I'd be here today talking to you about e-discovery and AI and redactions. So look, you never know.
Yep. Well, Tanya, thanks so much for joining us. Tanya
Thanks,
Kidney
George.
is a Senior Project Manager at Johnson Hana. I am George Socha. This has been eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. And Tanya, once again, thank you so much.
Thanks, George.